Ladies and gentlemen, welcome to the Law Societies of Hong Kong first Belt and Road webinar. The theme this year is Look Beyond COVID-19, Connect and Unite Through the Belt and Road and Law Tech. I am Corinne Wong, Council Member and member of the Belt and Road Conference Organizing Committee of the Law Society. Since 2017, the Law Society has been organizing an international Belt and Road Conference annually in Hong Kong to serve as a platform for professional exchanges among legal practitioners. Regrettably, the conference this year has been postponed due to the pandemic. But thankfully, with the digital technology advancements, we have come together here at the Law Society's first Belt and Road webinar to maintain and foster this close bonding, unhindered by geographic separation. In these extraordinary times, COVID-19 has forced many of us to confront a host of hard questions. Can parties to a contract terminate contractual obligations on the basis of force majeure clause or frustration under the pandemic? How is the legal community working together with the technology community in response to the challenges brought about by COVID-19? What are the lessons, challenges, and outcome of introducing corporate rescue regime? We will soon hear the invaluable insights from the eminent speakers from all over the world. With delight, the webinar has received an overwhelming response from 710 participants from 29 jurisdictions. Before we begin, may I remind you some important notes on Zoom webinar. Firstly, in this webinar, you are automatically muted and are in listening mode only. Second, simultaneous interpretation in English and Putonghua is available for this webinar. Please select the audio channel to hear the translated audio in your language of choice from the control panel at the bottom. Third, the chat room allows you to send chat messages to the host, the panelists, and attendees. And lastly, if you have any questions for the speakers, please feel free to type your question in the Q&A box during or after the presentation. For more detailed instructions on the Zoom webinar operations, please refer to the chat messages posted by the Law Society Secretariat. Without further ado, may I now first invite Ms. Melissa Pang, President of the Law Society of Hong Kong, to extend a warm welcome to the participants. Ms. Pang, please.
Ladies and gentlemen, welcome to the Law Society of Hong Kong's Belt and Road webinar titled Look Beyond COVID-19, Connect and Unite Through Belt and Road and Law Tech. The outbreak of COVID-19 has shaken the world and brought to us unprecedented challenges. Hong Kong was thrown into this crisis since the end of January 2020. 10 months have passed. Notwithstanding the difficulties arising from the current public health situation, the Law Society is striving our best to maintain the normal operation to serve our members since January. A balance is struck between fulfilling the essential duties with minimum disruption and ensuring a safe work environment for the protection of the Secretariat by implementing contingency work arrangement and infection control measures. Under the pandemic, the legal profession bodies and associations are all now looking at ways to assist their members. It is at these times of adversity that we must stay composed and motivated and double our effort to fulfill our roles and responsibilities in society to overcome the challenges. According to the World Health Organization, WHO, almost 200 vaccines for COVID-19 are currently being developed and tested. One was reported to have a very high success rate. While the medical experts are working hard to combat the pandemic, the general public also have an important role in helping to minimize the risk of COVID-19 spreading in the community by, for example, avoiding crowded places, wearing masks, maintaining social distancing, and seeking medical assistance immediately for any COVID symptoms. It is crucial for every one of us to maintain this united effort to combat this challenge. For the Law Society, in order to assist our members, we have worked on a range of relief measures, including reducing membership and practicing cert fees for 2021 and contribution to the professional indemnity scheme for the year 2020/2021, waiving continuous professional development course fees for 2020, and also CPD and risk management education obligation for 2019 and 2020, and distributing free surgical masks and mask keepers to members. Externally, the Law Society lobbied the government for allocation of funding from the Anti-Epidemic Fund to law firms, the Department of Justice and the Legal Aid Department for speedy settlement of legal fees to our members, landlords for reduced office rentals, and banks for preferential financial facility applicable to law firms. Court business is an essential public service. The effective and efficient administration of justice is integral to the judiciary's mission to uphold the rule of law. It is incumbent upon the judiciary to closely monitor the changing public health situation with a view to striking a proper balance between protecting public health and maintaining the access to justice. To deal with this, the Law Society maintained close liaison with the judiciary, reflecting views of our members and offering suggestions on how to address issues arising from the general adjournment of court operation during the pandemic, such as expediting the introduction of appropriate technology to facilitate the administration of justice. In view of the public health consideration, the judiciary had earlier announced the General Adjourned Period, GAP, starting from 29th of January. During this period, all hearings of the courts and tribunals would generally be adjourned to a date to be fixed. Court or tribunal registries and offices are also closed during this period. An urgent hearing will only be dealt with in accordance with the established mechanism. And from 4th of May onwards, all court proceedings have generally resumed as safely as the circumstances permit. During the general adjournment period, judiciary has been taking an incremental approach in using other alternative modes by hearing submission by telephone, video conferencing, or similar means of visual aid, and generally making use of technology. In phase 1, starting from 3rd of April, video conferencing facilities, VCF, have been used for remote hearings for suitable civil cases of the High Court. And in the second phase, starting from the 15th of June, there was an expanded practice for remote hearings by the use of VCF and telephone in civil cases, in some civil courts such as the Court of Appeal and the District Court. With the recent stabilization of public health situation, the judiciary has decided to fully resume court business in an incremental and orderly manner from 15th of September as far as possible, Appropriate social distancing and crowd management measures will be maintained to ensure that the courts will continue to carry on business as safely as the situation permits. The Law Society of Hong Kong, we are also instrumental in the establishment of the government's Law Tech Fund to assist practitioners to equip themselves with technological tools that enable them to continue practice, notwithstanding the public health condition. For legal practitioners, our professional training equips us with a deep knowledge of the substantive law and legal developments and a clear understanding of the functions of law in society. This webinar is a good opportunity for the legal profession to update and exchange views on how we can assist society to deal with the many legal issues arising from the pandemic. In addition to the expertise in substantive law, the core values embraced by the legal profession, namely independence of the judiciary, equality before the law, and respect for fundamental human rights, are intrinsic to the training of a lawyer. Such unique training not only prepares legal practitioners to uphold our duties and responsibilities, but also to fulfill a critical role in society to defend the rule of law, maintaining the fair administration of justice, and facilitate true access to justice. Notwithstanding the disruption caused by the pandemic, I would reiterate that we must continue to fulfill this important role in society. Not only should we remember to use our legal knowledge to help society to sail through this crisis, but also we must, whenever possible, promote a proper understanding of the rule of law and defend it whenever there are attempts to undermine or unfairly criticize it. We are honored to have eminent speakers gracing us today with their presence and enlightening presentations. Please enjoy the rest of the conference, and may I wish you a rewarding and fulfilling session. Thank you.
Thank you, Ms. Pang. We are honored to have Dr. Peter Lam, Chairman of Hong Kong Trade Development Council, to be our keynote speaker today. As the Chairman of TDC Belt and Road and Greater Bay Area Committee, Dr. Lam will share with us his valuable insights and experience on Look Beyond COVID-19, Connect and Unite through Belt and Road and Law Tech. Dr. Lam, please.
Thank you. Lisa, good afternoon. I'm honored to be the keynote speakers at the Law Society First Belt and Road webinar. The TDC has long been working with the Law Society of Hong Kong, and we are delighted to be part of this event. When Melissa invited me to speak, I wonder how to address the complex subject of law and technology in the Belt and Road, especially with experts such as you. When I thought through more about this, I think this is the value jointly created by the legal industry and technology that makes this topic meaningful. The value not only lies in the financial value of generate for your industry, but also in the economic and social value that your expertise create from the project that you advise on the dispute that you help to resolve, and the economic and social order that you help to maintain. Innovation in technology has helped to create new systems and infrastructures. Virtual law court, e-arbitration, AI, blockchain, and cloud technologies, automations, all these have a huge impact on helping you to deliver legal service in a way that was not possible in the past. Everyone needs to be tech ready and tech savvy these days. When this convergence of legal and tech, I believe the development of the Belt and Road Initiative is much easier. You may remember when the Belt and Road was first introduced, many people could not imagine how multi-billion-dollar cross-border projects could be done because there are so many legal systems, economics, and culture involved. Fast forward to now, COVID-19 has pushed us to embrace technology at a much faster rate than before. Technology has helped you to continue to provide legal service seamlessly and for the system to run smoothly. In fact, I'm delighted to know that Hong Kong has already applied IT to many of its online dispute resolution procedures. For example, the e-arbitrations, e-mediation, and deal-making EBRAM has been launched to provide one-stop online service for commercial parties worldwide. When this has been planned 7 years back, it takes a pandemic to make this platform a must for dispute resolutions, especially for cases related to the Belt and Road. I heard that during the COVID-19 outbreak, the demand for the Hong Kong International Arbitration Center's virtual hearing service had gone so much that about 85% of all hearings are conducted partially or entirely online in April and May this year. Throughout these 10 months, business has to tackle the impact of the pandemic, ensure economic activities continues, and prepare for recovery all at the same time. This triples the complexity of the challenge they face, so I can see an even greater need in the future for legal service that is supported by technologies. So where do the opportunities lie? Given the continued outbreak of COVID-19 around the world and the early economic recovery of mainland China, I believe the mainland is the place where we will drive global economic activities for at least the next few years. Let's start with the Greater Bay Areas. Since the time of the shipper in 2004, mainland China has been opening up its market to Hong Kong legal service sectors. Indeed, I know that in May 2020, Hong Kong law firms, including many international law firms, have set up 71 representative offices on the mainland, and which 40 of them were established since 2004. As policy and infrastructure across Guangdong, Hong Kong, and Macau become more closely integrated, it will become more flexible to cater to the increased activities across all areas of business, from construction to business service, to technology to consumer and lifestyle aspects. Meanwhile, Chinese investment and corporate activities also need to be reactivated both within the country, as well as internationally within the framework of the Belt and Road. In view of the political and economic uncertainties created by the pandemic, I think there will be a growing need for dispute resolution services. While Hong Kong reputation had undoubtedly taken a knock in the past years, our city is still a prime global financial hub and two-way platform between mainland China and Hong Kong and the world. Our city is not just home to a deep pool of highly skilled legal talent like you, but we also have an independent judiciary and an international respect legal system built over years of long established precedents. Organizations such as Law Society and the Hong Kong SAR governments have been working closely together over the years to establish Hong Kong as the designated International Dispute Resolution Center. And we have made much progress in the terms of lifting restrictions on legal frameworks, enabling professional and developing innovative tools to deliver legal services. A lot of work still needs to be done, such as mutual recognitions of qualifications, settling common standard, building knowledge base, and facilitating data system. But I am positive that all this effort will continue. This is why TDC can help. Over the years, we have working with partners such as Law Society to bring people together to exchange and opportunities. We have been supporting the Department of Justice to organize a legal service forum in the mainland since 2010, bringing legal professionals together in a city in the mainland each year. This event not only creates opportunities for Hong Kong legal sector, but also promote our capability and bring value to the many Chinese corporates that look for a unique combination of international and Chinese expertise. This meaningful event is complemented by sector-based conferences such as our Business of IP Asia Forum, Asian Logistics, Aviation and Maritime Conference, our Belt and Road Summit coming up on November 30th, and the Asian Finance Forum. In addition, we also use our overseas promotion to bring other sectors to connect with you and learn about Hong Kong's strength as an international legal hub. Smart Hong Kong in mainland China, Think Asia, Think Hong Kong, in developed markets and install Hong Kong in an emergency market are just some of the platforms they have welcomed your participations. Our Belt and Road portal also highlights Hong Kong Legal Service as a key partner for investors involved in the Belt and Road. Here, I would like to thank Malaysia for the fruitful cooperation between Law Society and the TDC. Thank you. Looking ahead, we will continue to create opportunities for the legal industry and to promote the excellency of your sector to the world. Before I close, let me say that we are undoubtedly facing very challenging times. To overcome that, we need to have a firm focus, clear direction, and the right tools to help us. Mainland China remains our most solid bedrock, and in the field to drive the engines of growth. We should look at the Greater Bay Areas as the springboard to capture opportunities in the mainland and the link between mainland and the Belt and Road. We also need to embrace technology and continue to use the innovations enabled by technology. And here I come back to the point I had made at the beginning. The practice of law and the application of technology go hand in hand these days. COVID-19 has speed up this convergence and helped us to equip the legal industry with innovations. The Law Society has long been the foresight to see this. And I congratulate you on driving this convergence to reinforce Hong Kong Road as a top international center for legal services. Now we need to look beyond COVID-19. Let's work together to help overcome the many challenges that lie ahead. Thank you.
May I now invite President Ms. Melissa Pang to present a souvenir to our keynote speaker, Dr. Lam, as a token of appreciation for his contribution and to take a photo.
Thank you.
Thank you, Dr. Lam and Ms. Pang. Let us now begin our discussion on topic 1, contrasting COVID-19 related contract termination under different legal systems. May I now introduce the moderator of this session, Mr. Amrali Nasir, Vice President of the Law Society of Hong Kong. Mr. Nasir, please.
Hong Kong, everyone. This is topic 1, contrasting COVID-19 related contract termination under different legal systems. It's been a very difficult year for commercial businesses dealing with COVID-19, frustration of contracts, and they don't really know what their position is. There's huge financial loss. We have a team of experts from various regions who will bring to you today their insight into this situation when contracts face different situations. So with that, I'm going to ask Mr. Luca Castellani, who is a legal officer in the Secretariat of the United Nations Commission on International Trade Law. His contributions are impressive in his CV, but in person he's even more impressive, as you will hear when he speaks about the uniform contract law and risk management in different legal systems. Luca.
Thank you very much, Chair, and good afternoon to everyone. I do apologize as I seem to be looming in the dark here. Truth is that I am actually in Vienna, Austria, and therefore I have the pleasure of talking to you before sunrise. Now, this being said, I think there was a last-minute change in the arrangement. It looks like you are controlling my slides from Hong Kong, which is also fine with me because I didn't change my slides at the last minute. So I will then ask you to change the slides. The topic of my brief conversation is, as you can see, uniform contract law and risk management in different legal systems. Now, of course, I will be talking from the perspective of UNCITRAL, the United Nations Commission on International Trade Law, and more generally of uniform contract law instruments. And first slide, please. So The starting point, of course, it's a policy consideration. That is to say, as we all know, we are discussing here, of course, the effects of the pandemic and better supply chain management, but of course, this is also in the framework of the Belt and Road Initiative. So needless to say, in the last 20, 30 years, we have seen more and more complex supply chains, which call for proactive supply chain management. In the case of the Belt and Road, obviously we have the belt and we have the road, that is to say we have the part that goes through Asia itself and the part that instead goes through the maritime way. So we go through different regions, different economic and legal systems. We have a significant diversity there. Now, what is important is that if we do rely on these complex supply chains, we really want to do proactive supply chain management, and we want to have some risk mitigation before we get into actually dealing with the effects of what went wrong. Risk mitigation means first and foremost to identify the risk and then to allocate the risk. Now here there is a really important issue that I believe sometimes is overlooked. That is to say, there is an assumption, especially when we look at from the perspective of certain jurisdictions, to think that all kinds of solutions, including very sophisticated solutions, are necessarily enforceable. Now, obviously, all practitioners are interested in enforcement and they want to enforce where their assets are. But not all countries have the same fundamental principles. In particular, I would like to stress differences with respect to recognition of freedom of contract and party autonomy. Let's think of some countries in Southeast Asia, some countries in Central Asia, for instance. They come from a very different perspective, and the perspective of most people here, which could be influenced by English law, where you have the most recognition of these principles, especially when it doesn't come to English domestic transactions. And the other issue is, of course, private international law. Private international law is in itself quite a complex matter. There are countries that don't even have legislation on this, and this is not because they rely on common law principle, because they do belong to civil law systems or to economies in transition. This is when it becomes really useful to rely on uniform law. Because uniform law, of course, in itself does want to take into account all the diversity in economic and legal systems. But at the same time, and I would like to stress this, there is a fundamental misunderstanding with respect to uniform law, especially uniform contract law. The main goal of uniform contract law is to promote freedom of contract, and therefore to buttress and foster risk allocation that the parties have agreed upon. It's not to impose some unusual solution that the parties have never heard of. This is one of the main reasons why this is the case is because uniform texts are not of mandatory application. At the same time, I would like to flag that they are really important tool for the specialist. And I'm really surprised when I see in many jurisdictions practitioners who claim to be specialists on international trade law, but they completely ignore uniform law. I don't think this is acceptable anymore today. I think this can be costly for the client. It can be costly also for the lawyer at this point, as cases of malpractice are increasing. Next slide, please. So the first solution, of course, is the CSG, United Nations Convention on Contracts for International Sale of Goods, 94 state parties and rising. It may be completely opted out. At the same time, if it's not opted out, then it applies by default. So when is it useful? It's useful in many cases. Here I highlight two. The first one, as I said before, is because it comes to validate the agreement of the parties on risk allocation throughout the supply chain. It is also useful when the parties did not have the time or did not think of having a dedicated contractual framework, and therefore it comes in with the default rules that are quite fair, they're predictable, they're well known. It's available in the 6 official languages of the United Nations, many other languages. There are about 5,000 cases reported on the CSG, so I would not say that it is not known in its content and application. It's complemented also by the other ancillary text. Here, I would just like to mention very briefly, there is a convention on the limitation period in the contracts for international sale of goods that has a specific provision, Article 21, that extends the limitation period in cases that I will call now of force majeure, but although this is the idea behind, but it's not called force majeure. If there is this force majeure situation, the limitation period is extended 1 year. It can be an interesting solution also for risk management. Next slide.
Luca, you have 2 minutes.
Yeah, most of it spent on asking to change slide, however. To my so the CSG is based on party autonomy, preservation of the effects of the contracts, and there is a general duty to cooperate. The effect is to temporarily exempt the liability of the non-performing party. There are these elements for the impediment. Impediment should be beyond control of the party, unforeseen, unforeseeable, and it cannot be avoided or overcome regardless of cost. The non-performing party has an obligation to notify, but also an obligation to cooperate to remove the impediment and mitigate the effects. So basically, this may look like, in a way, like good old force majeure, but there are some additional elements that are particularly useful in long-term contracts and in long-distance contracts. That is to say, there is a general duty to cooperate, which is generally seen as something useful to keep the economic value in the transaction. This is a temporary issue that cannot be avoided or overcome, no matter what the cost is. The slides will be shared. There's a link to the CSG digest prepared by Ansiter with a description of all the different scenarios and the case law. Next slide. There is sometimes confusion. There is an important text called the UNIDROIT Principles of International Commercial Contracts, which was not prepared by the United Nations, but by UNIDROIT, which is a venerable intergovernmental organization that sits in Rome. And this was prepared by a private group of experts, and it has a contractual nature. It can be incorporated in the contract, but if it's not, it cannot be applied, except to the very limited extent to which a court or an arbitrator will decide that it complements the CSG, and that's a long discussion that we don't have the time to undertake now.
Okay,
the main difference is that, sorry, I didn't hear you.
Your time is up. I'll just let you wrap up and then I'll let you.
No, okay, we can stop it here. People can read the slides. Thank you.
So I can let you cut it up during the question.
No, it's okay. It's fine. Thank you.
Thank you, Luca. Thank you very much. I know it's you've covered quite a lot in 8 minutes, which is quite a lot. I'll be very brief. May I now introduce Mr. Aditya Kurian from Milby & Myers. He's a consul with that firm, is a member of the International Dispute and Arbitration Group, and has solid practical experience. So he's going to talk about COVID-related contract termination in Hong Kong. Aditya. You can start.
Thank you, Amirali. I will be discussing the concepts of force majeure and frustration in Hong Kong and everything you need to know about these two concepts in 8 minutes. Now, there is no precise meaning of force majeure in English authorities, but there is an English case which seeks to discuss the meaning of force majeure. And I quote, "This term is used with reference to all circumstances independent of the will of man, and which it is not in his power to control, Thus, war, inundations, and epidemics are cases of force majeure. Now, force majeure is not a concept in English common law, and therefore, as a matter of principle, it will not apply unless the parties expressly agree to force majeure in their contract. So, put very simply, force majeure is an event which is beyond the reasonable control of an affected party, and the affected party's ability to perform its contractual obligations has been prevented. So what are the factors that need to be proved to rely, for an affected party to rely upon the protection of the force majeure clause? The affected party has to prove three things. One, that the supervening event is beyond the reasonable control of the affected party. Two, the affected party's ability to perform its contractual obligations has been prevented or impeded or hindered by the supervening event. And three, the affected party has taken all reasonable steps to mitigate the effects of the force majeure event and its consequences. And then that brings us to, if a party is able to prove the force majeure event and the impact of the force majeure event as agreed in the contract, what are the remedies available to the affected party? That depends on what the parties have agreed to in the contract, so it is part of the terms of the contract. Now, it's quite common to see as a remedy, parties commonly agreeing to an extension of time for the affected party to perform its obligation. It is also common to see that one of the remedies is that a party's obligation to perform is suspended during the duration of the the force majeure event. And sometimes parties also agree to the remedy of termination of the contract by the affected party if there is a force majeure event. So remedies and what exactly the remedies are subject to terms of contract. Now, I want to take you through a sample definition of a force majeure event. This is from one of our contracts, and certainly it's been entered into after the onset of COVID-19. Now, you can see in the first 4-5 sentences of the clause that it is a catch-all phrase, which is it is open-ended, and the intention is to capture any event which is beyond the reasonable control of an affected party and which materially affects the performance of that agreement by the party. And you can see that the second half of the clause has provided for express events which have been expressly identified, such as flood, lightning, storm, etc., and have deemed them as force majeure events. And you can see there that epidemic and COVID-19 related events have also been expressly included within the meaning of that definition. Now, the continuation of that clause, you can see another sample, and the structure here is quite common to see these days. The first is you'll see the impact of the force majeure event and what the parties have agreed to as the impact. Here it is totally or partially prevented from performing its obligations. That follows what a party is obligated to do, and that is to promptly notify the other party, which is a notification requirement. And soon after notification, you can see the remedy that is available to the affected party, and that is that the affected party is excused from performing its obligations. But that remedy is subject to subclause A, which is the condition of mitigation, and that the affected party shall take all reasonable steps to mitigate the effects of the force majeure event. Now, that brings us to the question as to whether COVID-19 is a force majeure event. The answer to that question will depend on the terms of your force majeure clause, in particular, the definition of a force majeure event. If your clause provides for an epidemic or a pandemic, and it has the catch-all phrase that you'd seen previously, which is open-ended, it is arguable that COVID-19 would fall within the meaning of that clause. But as a ground for contract termination, it depends on whether your remedy, the parties have agreed to termination as a remedy if a force majeure event takes place. And certainly what's most important is you'd have to prove after the force majeure event causation between force majeure event and non-performance of your contractual obligation. So we finished with force majeure, and now we'll come quickly to frustration, which, unlike force majeure, is a common law doctrine, and it is basically this: to rely on the protection of frustration, there has to be a supervening event which is not foreseeable, which is not caused by the fault of either of the parties, and it has to render a party's ability to perform its contractual obligations as impossible, or transform its obligation to radically different from what was contractually agreed. So it is a much more difficult and a higher standard to prove than force majeure. And if a party is successfully able to prove frustration, the remedy or the effect of it is that the party is automatically discharged from performing their contractual obligations, and the contract automatically comes to an end. Its relationship with force majeure clauses. Now, if you have a force majeure clause in the contract and clear language that excludes the remedy for frustration, you cannot rely on the doctrine of frustration. It is not a remedy available to you. But if your contract does not have a force majeure clause, then the remedy of frustration is available. But however, you have to meet the high standard prescribed, which is, as I mentioned, impossibility to perform. And second, your obligation is radically different from what was originally contracted. Now, the other difference between frustration and force majeure is that the courts will interpret a force majeure clause very literally against the party relying upon it. Now, frustration, again, it's very difficult to prove. There's a recent Hong Kong case, not very recent actually, but it concerns the SARS epidemic. And in that particular case, it was very difficult for the party to rely on frustration. It tried to set aside a 2-year lease agreement. This was the tenant, on the basis that the tenant was subject to a 10-day isolation order. The court felt that looking at the contract as a whole and a 2-year lease agreement, 10 days was just not enough to radically change its contractual obligation to perform. So that's all I have to discuss in these two concepts, and I wrapped it up in 8 minutes.
I'll come back to you, Aditya. Thank you very much.
Thank you.
So third, Anastasia Gordeva. She's qualified as a lawyer and accountant in Moscow, and she's the Belt and Road director at Charlton's. Her CV indicates a strong practical experience in advisory work, and she is going to effectively summarize force majeure under Russian civil law and Myanmar common law. Anastasia. You can start, Anastasia.
Спасибо. Good afternoon, everyone. Belt and Road involves legal work in different jurisdictions within the Belt and Road diaspora. And today I would like to provide you with the overview of force majeure concept under Russian civil law and Myanmar common law. In such challenging times, enforcing a force majeure rule may be the only option available to the affected parties. Businesses affected by natural disaster, war, protests, or pandemic may avoid obligations without being in breach of contract under existing contracts through recourse to statutory provisions or force majeure provisions in the contract itself. There are generally 3 essential elements of a force majeure event: occurring with or without human intervention, not reasonably foreseen by the parties, and beyond the party control and consequences which could not have been prevented. In common law countries, there is no general legal concept of force majeure. Rather, force majeure is a creature of contract. In English common law, it is generally understood to mean an event or circumstance that occurs and which prevents one or both parties to the contract from fulfilling their obligations under the contract. In civil law countries, force majeure is directly regulated by civil codes and acts as a legitimate ground for non-performance or not full performance of a contract. Speaking about law countries, we can look closer at Russia, where civil codes in Article 401 provides that an event qualifies as force majeure if a party is able to prove that the performance of the obligations has been impossible due to the event simultaneously having the following features: emergency and inevitability. Under Russian law, the decision that an event constitutes force majeure is made by the court on the request of the party claiming relief for force majeure. From the legal perspective, the official position of the executive authorities does not bind the court, although it might be taken into account along with other evidence. Russian law allows for the terms of a contract to provide for rules that differ from the rules established by default by statute. Therefore, when considering whether there are grounds for release from obligations or liability, the provisions of the contract must be considered first and foremost. Moreover, Article 401 of the Russian Civil Code expressly states that the following are not considered force majeure: default by subcontractors or other counterparties on which a party to a contract relied in order to perform its own obligations, the absence of the market of goods required for the performance of obligations, or the party's lack of funds. Although the term pandemics or epidemics is used frequently in contractual provisions on force majeure, Russian law does not have a clear answer as to whether the epidemic shall be considered a force majeure event. Importantly, as it was recently clarified by the Russian Supreme Court, the pandemic itself cannot constitute a force majeure event. Only specific consequences of COVID-19, such as raw material supply shortages and government, would constitute a force majeure. In many cases, the default would likely be caused by several factors, such as restrictions related to public events, transportation, export of certain types of goods, etc. Thus, if the list of force majeure events in the contract includes a pandemic or an epidemic, this would simplify the process of providing that events due to COVID-19 qualify as a force majeure event. In any case, the party will be required to prove that the event has met the above tests. Now have a look at Myanmar's approach. The legal system in Myanmar is based on English common law, and as mentioned before, there is no generic definition of force majeure. Rather, it is a matter of contractual interpretation in each case, and the defaulting party must prove that one of the events referred to in the force majeure clause has occurred, they have been prevented, hindered, or delayed from performance by that event, non-performance was due to circumstances outside of their control, and there were no reasonable steps that could have been taken to avoid or mitigate against the event. In Myanmar, this common law concept of force majeure is governed under Section 56 of the Myanmar Contract Act. The section adopts the English doctrine of frustration. This doctrine provides that a contract may be terminated on the ground of frustration when something occurs after the formation of the contract which renders it physically or commercially impossible to fulfill the contract or transforms the obligations to perform into a radically different obligation from that undertaking at that time of entry into the contract.
1 minute, Anastasia.
Sure, thank you. Force majeure clauses in contracts and the stipulations under the contract may differ from case to case. There may be force majeure clauses where upon continuation of force majeure events beyond a certain number of days would automatically lead to a termination of the contract. In most contracts, the affected party wishing to enforce a force majeure clause must send the notice to the other party within a specified number of days from the occurrence of the events. Depending on the nature of the case, the contract may be terminated or extension of time will be granted to perform the contract upon the force majeure event ending. As many other countries, Myanmar has imposed various measures to curb the spread of COVID-19 that has consequently resulted in difficulties for businesses to perform contractual obligations. Well, can parties in Myanmar rely on force majeure clause that allows for non-performance of contractual obligations without frustrating the contract? The answer depends on whether the contract contains a force majeure clause and whether the clause covers a pandemic event such as COVID-19 outbreak. So this is the end of my presentation. I would
Thank
be
you,
happy to answer
Anastasia.
questions.
You filled it exactly 8 minutes. Now may I introduce Ms. Xiaoli Gao, who is the CEO of the Supreme People's Court of the People's Republic of China. She's also the Director General of the International Cooperation Department and Judge of the International Commercial Court. She will introduce the application of force majeure clause in mainland law of China. Ms. Gao.
Good afternoon, everyone.
Good afternoon.
Yeah, is that okay?
Yes, perfect.
Yes. Okay. Good afternoon, everyone. I'm very happy to join this webinar and talking about the legal issues arising from the pandemic with you. I would like to introduce the application of the force majeure clause in Chinese mainland law. Force majeure is a very important concept in our civil law, both in the contract law and in the tort law. It may lead to the termination of the contract and the exemption of the liability and the suspension of the time limitation on the action. I would like to introduce the legislation and then the judicial practice. The basic provision of the force majeure in Chinese law is located in the general provisions of civil law of China. Article 180 provides, civil liabilities shall not be borne for failure to perform a civil obligation if it is caused by force majeure, except as otherwise provided by law. Force majeure means unforeseeable, unavoidable, and insurmountable objective conditions. This provision comes from the general principle of civil law of China, the Article 107 and 153. Now, this provision has been moved to the brand new civil code. You know, we have the civil code now. It's the same article 118. This civil code will come into force the first day of next year. And the typical provision of force majeure in Chinese law is located in the contract law. Article 117 provides, in case that a contract is not able to be performed because of force majeure, the liabilities shall be exempted in part or only in light of the effects of force majeure, except as otherwise stipulated by law. If the force majeure occurs after one party has delayed in performance, the liability may not be exempted. Article 118 provides one party to a contract that is not able to perform the contract because of force majeure shall make a notice to the other party promptly so as to reduce the probable losses to the other party and provide evidence within a reasonable time limit. Now these two articles has been moved to the Civil Code, Article 519. So that's a legislation. And what is the except as otherwise stipulated by law? I can give you some examples. According to Article 70 of the Tort Liability Law and Article 160 of the Civil Aviation Law, Article 48 of the Postal Law of China, the liability may not be exempted even though the force majeure event occurs. So that's the exemptions. Generally speaking, in judicial practice, we don't have so many cases concerning the issue of force majeure. For example, in my personal judicial experience, around 1,000 cases, I have only 2 cases involving the issue of force majeure. In these 2 cases, I must decide whether or not the administrative order meet the requirement of force majeure and lead to the termination of the contract and the exemption of the liability of the party. In this April, you know, during this pandemic, the force majeure become a very hot topic. In this April, the Supreme People's Court delivered a series of judicial indirection to overcome the adverse effect of this pandemic in judiciary. One of it is this one, the guiding opinion on several issues concerning properly handling civil cases related to COVID-19. There's 2 articles is concerning the application of the force majeure rules. It's very long, so I just put it here for your reference. Because time is very limited, so I can only share with you some key points in judicial practice. The first one is there must be unforeseeable, unavoidable, and insurmountable objective conditions. From one perspective, the parties have the duty of care. From the other perspective, the accident cannot be attributed to the parties. So from this criteria, the COVID-19 pandemic and the governmental actions to prevent and control the pandemic can meet this criteria of more force majeure event. The second one is the non-performance party must make notice to the other party promptly so as to reduce the probable losses. The third point is this party must provide evidence within a reasonable time limit. And the fourth point is for the when the party has the hardship to perform the obligations of the contract is because of the force majeure events directly. It's directly come from these events. There's the following legal effects. The first one, if the performance of the contract, if the parties can perform the obligation, but the performance of the contract will be obvious unfair because of the force majeure events, the parties will have the right to modify or revoke the contract. If the parties cannot perform the obligation of the contract anymore and fails to achieve the purpose of the contract, they have the right to terminate the contract. And the liabilities, both are the kind of breach of contract. The liabilities for breach of contract shall be exempted in part or only in light of the effects of force majeure. The fifth point is a limitation of action shall be suspended during the last 6 months of the limitation if the plaintiff cannot exercise his right of claim because of force majeure. The last point is sometimes the parties will have the clause concerning force majeure in their contract. Generally speaking, the Chinese court will respect the force majeure clause in a valid contract. But if the parties enlarge or limit or exclude the force majeure clause in their contract, which will be contrary to the public policy especially in the consumer contract and the labor contract, it will be considered as invalid clause. So generally speaking, that's the very short introduce of the legislation and judicial practice of force majeure clause in Chinese mainland law. So thank you for your patience.
Thank you, Ms. Yao. Thank you very much. Finally, but not least, we have Mr. David Yu, who's co-founder of Links Law Office, currently the president of the Shanghai Arbitration Association. He'll be speaking about the change of circumstances under Civil Code of China. David, you have a very lengthy slide, so I'd ask you to summarize it.
Sure, I'll keep it short. So can everyone see my slides?
Yes.
Okay, just as Mark just mentioned, the force majeure, practicing in China. So I'll go through another topic, that's a change of circumstances under the Civil Code of China. And as the moderator said, I prepare a lengthy slide, so I have to speak quickly. So my apologies to the simultaneous translator. So basically, there's an essential rules range of circumstances under China law. That's on the left side, that's come from the English system, or case law system. On the other right side, it's come from the under the PRC law, or it's originated from the civil law system. I will not name it separately. So basically, a contract is a contract. So you have to, the provisions of the agreement must be kept, and the obligations of a contract must be performed at any cost, which you can find either in the English law system or the civil law system. If you look at the Civil Code of China, that's Article 119. As contracts established in accordance with law shall be legally binding upon the parties. And the Article 465, paragraph 1, also mentioned a contract that has been lawfully established shall be protected by the law. In other words, that the parties to a contract has to perform its obligations as it specified in a contract. As I said, that no corresponding rules under the Chinese law, whether nominalism, but we have a similar concept under the PRC law. Parties usually refers to the Article 119 and 465 of the Civil Code. And there's an exception of the exemption of performance of a contract. That's a monetary or pecuniary liabilities are not exempted. If you look at Article 580, paragraph 1, it says if either party to a contract fails to discharge non-pecuniary liabilities or fails to perform non-pecuniary liabilities according to the contractual agreement, and the other party can discharge the agreement except one where the discharge is legally or practically impossible, or secondly, where the subject matter of the liabilities is not suitable for compulsory discharge, or the third, where the relevant creditors fails to demand the discharge within a reasonable time. And we can find the similar cases in China. And the civil, the other principle is good faith, fairness, and reasonableness. If you would like to, rely on the change of circumstances. If you look at the Civil Code of Article 7, Civil civil subjects should carry out civil activities according to the principles of good faith, uphold honest and honor commitments. Article 509, paragraph 1 and 2, set out the same principles for the both parties should acting in good faith. And the Supreme Court, they have a case in 2016, which says that obligators should, according to the nature, content, and the purpose as agreed upon by the parties, and the characteristics of a subject matter, perform contractual obligations in accordance with the principle of good faith. So a contract is a contract. You have to, the parties have to follow the contract, or they are bound by the provisions of a contract. But there are some exceptions, which says, principle of assumption of such a clause by means of complementary interpretation of contract, and the theory of cessation of the basis of a contract, and the frustration of the contract, which is a common law, term or civil law term. But we also have the commercial impracticability under the Chinese law. If you look at the difference between the change of circumstances and the force majeure, as Justice Mark just mentioned, that earlier this year, the Standing Committee of CPC, China People's Congress, as well as the Chinese Supreme Court issued several notice on how to implement force majeure clause under the pandemic. And but for most of the cases, the party can choose either use the force majeure, which is operated by operation of the law, or more softly they can use the change of circumstances to alter or to renegotiate the terms of a contract. So in practice, parties may use the change of circumstances as an excuse or as a reason to amend or to alter their contractual obligation. And
David, 2.5 minutes.
Okay, so how to use the change of circumstances? The first is you have to, after the conclusion of a contract, and secondly, you have to prove the materiality, fundamentality, and the extraordinariness of the change of circumstances, which is change of the foundation of a contract. I have only half minute.
Yes, 1 minute. I'll give you 1 minute.
Thank you. So here's a definition of materiality and unforeseeability, and that's a comparison of which is commercial risk and which is a change of circumstances.
I found this a very interesting slide, that one. Very good.
Okay, here I listed some cases. I quoted the reasoning of some judgment made by the Justice of Supreme Court. And last but not least, here's a difference. Comparison between force majeure and change of circumstances. And the most important is if you use the force majeure, which will result the termination of agreement or suspension of agreement. But if you use a change of circumstances to as a reason, sometimes you continue the performance of a contract with the modification, or in some cases it's termination of a contract. Sorry, time's out. I'll leave, maybe I can take some questions after
Yes.
my presentation. Thank
David,
you.
let's see what questions we have. We have one question from a delegate, Salty. We have, let me see, it's for Ms. Gao, and it says, what is the test or guideline for things said to be unforeseeable to be eligible level for protection from contractual liability under force majeure, given that technically nothing is impossible, everything must be foreseeable So to meet with the test of unforeseeability is virtually impossible. That's a very good technical question. So it's addressed to Ms. Gao, but all of you can address that question since that's been raised. So Ms. Gao first, if you're able to.
Okay. Okay, very good questions. Yeah.
Yes.
Yeah, the unforeseeable is not so clearly. Yeah, it's very difficult for the judge to decide whether or not it's foreseeable for the for this party.
COVID-19, but COVID-19 really is a progression of the H1N1. So some people could say, well, it's easily, it's within the knowledge of people that viruses will mutate. And so is it really unforeseeable that COVID would appear? Of course, COVID is totally different from SARS and other variants of H1N1. So yeah, it's a very good question. And I suppose the evidence you'd have to be presented to the courts would be a lot of evidence about its effect and its effect on the contract, if you're talking about common law. Did you?
Yeah, I agree. I think it's fair to say that COVID-19 is foreseeable now, but the impact of COVID-19 in terms of what restrictions are, this volatile and develops in very different ways. It's contained and then after that it comes back again. So I think while parties can foresee COVID-19, the consequential impact that it has, where governments would reintroduce stringent measures and that could impact upon your transaction, the contract, that may be unforeseeable. Yes. So I think it's really the consideration needs to be whether the impact of the event is foreseeable.
Yeah, in my contracts, I have since SARS put in words like H1N1 SARS and any of its variants, and so that's been since SARS. Anastasia, what about from your perspective? You've looked at two different regions, Russia and Myanmar. What's your response to that delegate's question? Foreseeability, is it really an unforeseeable event from your legal jurisdictions?
Well, to be honest, I feel like we all will try to become a fortune tellers, and starting from nowadays, we will try to input as many definitions of force majeure or what can it be in any contract. And I believe we will also try to expand the meaning by covering all possible outcomes and all possible events that may occur in the future.
Yeah. Luca, are you still awake? Luca.
Yes.
What do you think?
I am awake. No, I cannot comment because I'm not a lawyer. So
yes.
We don't have an opinion. We are driven by the interpretation of courts.
Yes. Yes.
If you look at the statistical analysis of the past, there's a lot of case law that says that epidemics are foreseeable. But
yes.
That's just what I'm saying. Just look at the data set.
Yeah. The evidence would be announcement by an international organization that is a pandemic or a local country that declares a pandemic. Epidemic, sorry.
That's definitely a point that it is not appropriate for me to comment upon because the judge is independent in making its deliberations.
Yes.
So every legal system has its own way of dealing with it. Yeah. And so you leave it to the adjudicator, and we cannot go to that level, of predictability. The only thing drafted contracts should take care of this. That's a basic rule.
Yeah. David, is there something that you wish to add? Oh, we have two more questions. David, we have two questions. Can I read association?
Two questions to me.
Yeah.
Wow.
They may be, what's that? rubasic stentus, but is the theory of pacta sunt servanda also being followed from Perry?
Yeah, my understanding is yes. As I say, the contract is a contract. As long as the contract is signed, the parties has to honor the contract. Sorry, has to honor the contract and perform the application under it.
Right. Okay. So the other thing I'd like to discuss is if any of you got any experience of instances of force majeure that you'd like to share with our delegates. Aditya, do you ask you to start with that?
Yes. This year, after the onset of COVID-19 and after it was declared by the WHO as a pandemic, I have seen at least two instances, and both are international disputes that are seated in Hong Kong, where in both clauses provided for force majeure, and the definition of force majeure event in both those cases actually had the express words of epidemic, as well as the catch-all phrase that I referred to in my presentation, which is very open-ended. So in one of them, COVID-19 did fall within the meaning of the clause, and it also did prevent our client from performing its contractual obligation. In addition, the client had also strictly complied with all preconditions to the force majeure clause, so it was actually able to rely upon its protection and excuse itself from performing the contract. But in the second case, we saw that although COVID-19 fell within the meaning of a force majeure event in the clause, and it did in fact prevent the party from performing its obligation, the party had failed to provide prompt notification of the force majeure event, and it actually provided notification 9 months later, and therefore was unable to rely on the protection of the force majeure clause to avail of the remedy provided, which was to an extension of time to perform its obligation. So two cases where the clauses were fairly common, but the outcomes are very different.
Yeah. Anyone else have any experiences to share with our members, with our delegates? COVID-19? Can they hear me? Oh, okay. I have a new question. What about the uncertainty as to when business can normalize with the continuation of the mutation or of the COVID? Can that excuse a party from continuing its performance? So Aditya, you've got experience of that.
Yes, so yes, all that is unforeseeable, certainly, but it's a question of fact. Will this uncertainty, what is the impact that it will have on your contractual obligation? Now, if it prevents you or impedes or hinders you from performing your contractual obligation, then you can certainly rely on the protection of the force majeure clause, subject to any conditions of, let's say mitigation. But it really is a question of fact and whether it has impacted your obligation to perform.
Okay. Anastasia, can I ask you a question? On Russian law, the event of force majeure you talk about must be simultaneously meet the criteria of emergency and inevitability. Can you clarify what is implied under these two relatively ambiguous words?
Thank you. Let me try to. Starting from emergency, what does it mean emergency? So the nature of emergency is exceptional, right? And its occurrence is not common in the relevant circumstances. When it's the party claiming the force majeure could not have reasonably foreseen it when the contract was made. So therefore, for the purpose of qualifying the event as a force majeure, the timing of entry into the contract could play a really significant role. And as for the inevitability, it should be obvious that any other party to a civil transaction engaged in a similar activity could not have avoided the occurrence of this event or its consequences. So Russian court practice has not developed a uniform approach as to what extent the party must use its endeavors in order to avoid the occurrence of the relevant events. So therefore, any endeavors made by the party, like to do so, to be assessed by the courts only on a case-by-case basis.
Right. Okay. Aditya, what about, is there a duty to mitigate?
Yes, in most cases, you will find force majeure clauses that have preconditions to availing the remedy. And I've seen many contracts where you have force majeure clauses providing for mitigation as a precondition to availing the remedy. So if there is a force majeure event and it does have an impact on your contractual obligation, you will then need to take all reasonable steps to mitigate the effect of the force majeure event. And that would mean seeing if there are other avenues by which you can perform the contract, how you can perform your contractual obligations. For example, if you're a supplier that has obligations to the buyer, if the event affects your performance of the obligation, you need to check if, are there alternate manufacturers in a different location that you could approach to perform your obligation. Now, that is again fact specific, and the reasonableness of a mitigation measure will need to be interpreted by the court against the additional burden and costs incurred by the affected party.
That raises an interesting question. We have 2 minutes. If you have a situation where you have a COVID situation, and then you have a supplier who doesn't really follow wearing masks or any of those provisions which are recommended in order to abate the transmittability of the disease, would that be, an event which excludes force majeure, if you could prove it? You could get a country where that doesn't actually, they don't bother to wear masks, they don't bother, and then yet you get an infection in a warehouse because of lack of adopting the correct safety risks, protocols, and you're therefore not able to deliver. So yes, it is COVID, but it arises because of a lack of adopting the relevant risk measures.
Yes, and in that case, it would be
Oh, sorry, you can.
So in that case, it would be the fault of the other party. And in that situation, you could rely on the force majeure clause because it is not your fault that the other party has breached any sort of government regulations that have then impacted upon your ability to perform the contract. Because it is, you haven't been at fault. And so you can still go ahead and avail of the protection of the clause.
Difficult to...
Now, if the fault is yours, then certainly you will not be in a position to, this has to be a supervening event, which is of no fault by either party.
I have one last question. As regards impossibility to perform, would considerable expense to perform, which is outside the normal expectation of the party, be considered as an impossibility? I think, Anastasia, you covered that in yours, and it's excluded. I think somebody else covered it under Chinese law is excluded, right? Expense.
It is.
Anastasia, you said it's excluded under your presentation.
Yes,
I think, David, you also covered that as is excluded. Cost alone. Cost beyond the expectation of the parties, did it? Yeah?
Is this in relation to force majeure or frustration?
Majeure. Yeah, force majeure, I think. It doesn't say, it's in regards to impossibility.
Yes, sorry, what's the question again?
As regards impossibility to perform, would considerable expense to perform, which is outside the normal expectation of a party, be considered as an impossibility?
It wouldn't be considered as an impossibility. Now, you could say that there is in terms of mitigation, you could say that, yes, this is another available alternate means of performing the obligation, but it is onerous, it is very expensive, and therefore it is unreasonable for us to adopt this mitigation measure.
Yeah.
And then you could avail of the protection of the force majeure clause.
Okay. So you can see there's different,
Because
depending on the laws of different countries. I'm going to have to stop because you're finishing.
Yeah.
Because the laws of different countries, it's always good to get legal advice. Also, if you have a contract, as for Madhuti's example, is to go back to your contract immediately, look at the provisions that you have to comply with in order to take advantage of that particular clause. So I'd like to end by thanking all our speakers for their valuable time. I'd like to apologize for cutting you short, and thank you very much, everyone.
thank you.
Thank you.
Thank you.
Thank you, all the guests and speakers, for your fruitful sharing, which I'm sure we have benefited greatly. Mr. Nasir, moderator of the session, has now presented a souvenir to Mr. Kurian as the representative of all the guest speakers today for this session, for their contribution, and to take a photo. We have just completed that. And now the discussion on this session one has fruitfully ended here. We will now take a 10-minute break, and then before commencing our discussion on topic 2. So see you in a minute.